Clients are often confused about the security clearance suspension and revocation process, as well as the due process rights that they are entitled to. In this video, I'd like to discuss with you what you can expect should you receive a letter of intent to revoke your clearance. This video will focus primarily on the Department of Defense process, but that process is substantially similar to the process in other departments such as the NSA, the CIA, or the DIA. A recent report by the Congressional Research Office found that there are around 4.3 million people in the United States with a security clearance. Of those, about 2.9 million have a classified or secret level of clearance, and around 1.4 million have a clearance at the top secret level. The depth and breadth of investigations required for clearance determinations vary based on the level of risk, position sensitivity, and access requirements. After completion of these investigations and the granting of a clearance, periodic reinvestigations are required to maintain the clearance. The current reinvestigation cycles are every 5 years for top secret clearance or access to sensitive, compartmentalized information, every 10 years for secret clearance, and every 15 years for a confidential. What the investigations are trying to do is provide a balanced assessment of the positive qualities as well as potentially disqualifying behaviors to create a whole person concept. They do this by considering and evaluating you through 13 adjudicative guidelines. These guidelines are allegiance to the United States, foreign influence, foreign preference, sexual behavior, personal conduct, financial considerations, alcohol consumption, drug involvement, psychological conditions, criminal conduct, handling protected information, outside activities, and use of information technology systems. Your fitness to maintain your clearance is continuously evaluated against these guidelines, and it can be suspended or revoked at any time. The controlling regulations for assigning responsibilities and for establishing procedures for personnel security actions are the DoD Manual 5200.02, Procedures for the DoD Personnel Security Program, and DoD Directive 5220.6, Defense Industrial Personnel Security Clearance Review Program. Before outlining the process for appealing a clearance decision, I think it is important to provide a little bit of background about who the players are in the clearance process. The person you are probably most familiar with is the Security Management Officer. This is the individual responsible for the local administration and oversight of personnel security program and serves as a liaison between your commander and the Department of Defense Consolidated Adjudications Facility. Next, we have the DoD Consolidated Adjudications Facility, or DODCAF. DODCAF is the sole authority to determine the security clearance eligibility for non-intelligence agency DoD personnel in sensitive positions or requiring access to classified material. Previously, each service department had its own consolidated adjudications facility, such as the Department of the Navy Consolidated Adjudications Facility or the Army Consolidated Adjudications Facility, and so on. But in 2012, the decision was made to combine them in order to improve efficiency and ensure the same standards were applied across the DoD. The DoD Consolidated Adjudications Facility is located at Fort Meade, Maryland. The Personnel Security Appeals Board, known as the PSAB, is a 3-member panel that renders final decisions when an unfavorable national security determination is appealed. Each DoD component has its own PSAB. Each 3-member PSAB consists of a president in the rank of at least 06 or GS-15 and 2 members with a rank of at least 05 or GS-14. In addition, at least 1 member of the board must be equivalent or senior in rank to the appellant. Another important role player in the process is the Defense Office of Hearings and Appeals, or DOA. DOA provides an appellant the opportunity to present a case in person to an administrative judge who will then forward a recommendation to the Personnel Security Appeals Board. Now that we understand the key role players in the process, let's discuss the timeline for how these types of cases typically progress. First, there is usually some type of incident that gains the attention of the Security Management Officer. An incident is anything that may bring into question the person's trustworthiness, honesty, or loyalty. This may be an allegation of criminal misconduct, the mishandling of classified information, or anything else related to the 13 adjudicative guidelines mentioned earlier. Upon discovery of the incident, the security manager inputs the derogatory information into a program called JPAS, the Joint Personnel Adjudication System. Once DODCAF reviews the derogatory information in JPAS, they have 15 days to make an initial determination to suspend clearance eligibility or not. In the interim, the commander or adjudicative authority authorized to suspend local access to classified information will make a determination of whether or not to do so. If DODCAF determines that the clearance eligibility should be suspended, they are required to notify persons in writing when their eligibility has been suspended and include a brief statement of the reasons for the suspension of eligibility. This letter is called a letter of intent, an LOI, and will include information about an individual's right to an attorney, right to request and review certain documents considered in making the unfavorable determination, right to respond, and suggestions for doing so. Accompanying the letter of intent, a written statement of reasons, an SOR, must provide a comprehensive and detailed explanation for the basis of the unfavorable security eligibility determination. The individual must notify the adjudication facility in writing within 10 calendar days of receipt of the LOI and SOR whether he or she intends to reply to the LOI and SOR. If the election to reply is made, an individual has 30 days to submit a written response, and a 30-day extension may be granted. During this 30 to 60-day period, it is important for the individual to draft a response which clearly mitigates the bases described in the Statement of Reasons. Since time is of the essence in these types of cases, I recommend that you consult with or retain an attorney as early in this process as possible. Within 60 days of submission of a response by the individual, DODCAF reviews the response and makes a determination as to whether the individual provided sufficient information to mitigate the derogatory information. When DODCAF renders an unfavorable determination, it provides the individual, via the appropriate component or command security office, a written letter of denial for those applying for a clearance, or a written letter of revocation for those who already had a clearance, stating the final determination for each adjudicative guideline mentioned in the Statement of Reasons. In addition, the letter of revocation will include information on how to appeal the unfavorable determination. Within 10 days of receipt of the letter of denial or letter of revocation, the individual must return the notice of intent to appeal, stating whether the individual does or does not intend to appeal. If the decision to appeal is made, the individual has two options for doing so. The individual may file a written appeal directly to the PSAB or may request a personal appearance before the DOA. If electing a written appeal to the PSAB, the individual has 30 days from receipt of the letter of denial or letter of revocation to write the applicable DoD component PSAB, stating reasons why the denial or revocation should be overturned and to provide any additional relevant information that may have a bearing on the case. This submission must be routed via the individual's security management office. If electing personal appearance before the DOA, a hearing before an administrative judge is typically scheduled within 30 days of the request. At this hearing, appellants may be represented by counsel at their own expense, make oral presentations, respond to questions posed by counsel, and present evidence and witnesses. The DOA judge conducts a de novo review of the unmitigated adjudicative guideline issues stated in the LOD or the LOR and issues generally within 30 days of the close of the record written recommendations to the appropriate PSAB to sustain or overturn the denial or revocation. Whether reviewing the written appeal submitted directly to them by the appellant or considering the recommendation from the administrative judge, the PSAB has the final decision authority. The PSAB typically makes the final decision within 45 days of receipt of the written appeal or within 30 days of the receipt of the DOA administrative judge recommendation. PSAB delivers the final decision to the appellant via the appellant's security management office, and this written decision identifies each adjudicative guideline issue stated in the LOD or LOR that remains unmitigated after the appeal and the rationale for the final disposition of the appeal. DODCAF then updates JPAS to reflect this decision. At this point, there are no further administrative means to appeal. After 1 year, commanders may request reconsideration of unfavorable national security determinations for individuals within their command to address specific mission needs. The revocation process is swift and the consequences can be severe. If you find yourself in a situation where your clearance eligibility is in peril, it is important that you get expert assistance immediately. DODCAF, PSABs, and DOAs are looking for specific mitigating factors for each adjudicative guideline. Hiring an attorney with experience in this area can dramatically increase your chances of keeping your clearance and your job. I hope this video has been helpful in increasing your understanding of this topic. Thank you for your attention and for your service to this country.